Alex here with part 178 of the My Docket series on child custody and visitation. As in my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We now go into the telephonic conference. I am very excited to go through this because I've never seen it, and there's a few things that I want to mention about that. Apparently, attorneys can go to these conferences without their clients present, and the conferences are apparently held on the record, which means you can pull a JAFS video, at least in Nevada, and you can review what was said at the conference. I think that in hindsight, I would strongly recommend, I would have definitely asked for that JAFS video and taken a look at it, but I would strongly recommend to my viewers, if you find out your attorneys are going to these conferences, you should be getting those videos and listening to what your attorney is saying, because this is an opportunity for you to know what your attorney thinks about your case without you present, and also whether or not your attorney is fighting for you without you present. And if not, maybe that's a signal to you to find some way to take care of that situation, either removing the attorney or some other remedy. I am going to go through this video for the first time right now, and you're going to get my reactions, of course, as with any hearing video, as I interject into the video for the first time. And I hope that whatever occurred at this video is something, well, at least with regards to my attorney, I hope it's something that I can be proud of and bolsters my confidence in not just my attorney specifically, but the legal profession. But I won't know until I go through it. And so with all of that being said, I think we should go ahead and get straight into that hearing video.
Good morning, Counsel.
Good morning, Your Honor.
Good morning.
We are here on case number FV08-03200, Falcone versus Farrar. If I may have appearances, please.
Yes, Monica Caffaratti for Alexander Falcone.
James Barnes, Your Honor, on behalf of Monica Farrar.
Good morning. Counsel, the reason that we're having this hearing is to deal with the order after hearing, so that we don't have continued motion practice on this. Since the court's order that was entered, on September 25th, have the parties gotten together to try and resolve anything further with regard to the order?
No, Your Honor. I filed the objection, and Mr. Barnes filed his response. Other than that, we've been just waiting for the hearing.
All right.
Or for the phone conference.
Okay, so let's then... At the notice of compliance, I've got the objection. Mr. Barnes, with your permission, I'm going to use the objection as the outline for today's hearing.
Your Honor, in our request for submission, I kind of outlined the objections and then our response to each objection. So that may be a better document to use.
I'm popping over to
Yeah, you could see that even the court is confused by what this attorney did. The request for submission shouldn't have anything substantive in it. It should just submit documents to the court for consideration. So the fact that he included or listed out his responses to our objection in his request for submission was not only bizarre to me, but to the court as well.
Let's see. Your notice of compliance?
The request for submission filed on September 10th.
Okay. I don't have that in my binder. Just a second, and I'll pull it up off of the website, okay?
Yeah.
Oh, would you? The clerk's going to print it for me. That'll make it easier. And counsel, I don't know what time this hearing was scheduled for. We had two different times at the court. We kind of split the difference.
I had 10 o'clock, Your Honor.
We had 10 o'clock on one calendar and 10:30 on the other. All right, I've got the request for submission in front of me. And with regard to the custody portion, what is your objection specifically, counsel?
Your Honor, I had put that in there. Basically, I don't object to the custody arrangement. It was as outlined, and then I listed my specific objections. I may have just been being too specific, but I would withdraw that objection to the first part
Right.
that I had placed in there.
Thank you very much. Then we've got the objection with regard to child support.
Yes. We had never agreed that the garnishment on the current child support should stop. The direct deposit was in reference to the $50 per month payment on the arrearages.
Mr. Barnes?
My review of the Jazz video, Your Honor, at some point it wasn't completely clear on what was agreed, but the statement was made that there would be a garnishment or a direct deposit would be made, and then that would be the sole way that payments will be given moving forward. I took that language to mean that all payments moving forward would just be through direct deposit and no longer garnished.
And our position is that that was just for the $50 payment.
I can understand both sides, and let's make it clean. We've got a garnishment that's already in place, and I like that as far as child support goes, because the DA's office then has an actual record of every payment that is made, so there can't be a back and forth about whether a payment was made or whether it wasn't made. Any other payments that need to be made, if that includes the $50 payments or payments for one half of any medical expenses, anything like that, is going to be made through the payment as we've already set forth. So that will be done by the bank exchange.
Very good.
But the garnishment should stay in place. I think that's just cleaner.
Thank you, Your Honor.
So we'll need to alter the order to comply with that.
Yes, Your Honor.
The flight expense.
Yes. Let me see here.
Okay.
We agreed with that objection, Your Honor, and we changed it.
That has been dealt with, so that shouldn't be a problem for you any longer, Ms. Caffaratti.
And is that on the, I'm sorry, which section was that?
You just wanted to make sure that the flight expense included the child only, not Ms. Farrar, and that has been changed.
Correct. Thank you, Your Honor.
And as far as the parenting plan regarding where visitation is to take place, that amendment has been made as well.
Yes, Your Honor.
Okay. Thank you, Your Honor.
So, the 7-day vacation periods, Mr. Barnes, it's my understanding that you've amended on that with regard to that as well.
No, Your Honor.
Okay.
It's a little, the way it worked out was kind of confusing. There's generally a 30-day, in our initial parenting plan that we submitted before went to the hearing, there was a 30-day notice requirement. But Ms. Farrar is required to give at least 60 days prior notice before Armando's going to come to Reno.
Okay.
So there's two different periods there, but there was no agreement to change the initial 30-day notice requirement. However, if Ms. Farrar is going to take Armando to Reno, she has to give 60 days prior notice.
Okay. So what we have is a specific provision that takes precedence over the general provision in just that circumstance.
Correct.
Ms. Caffaratti, do you understand that?
Yes,
And,
we're in agreement.
Your client understands how that's going to work now?
Yes, so just when Ms. Farrar takes Armando to Reno or exercises for visitation in Reno, she's required for 60 days, but any other visitation, or including the 7-day vacation, would be 30 days. Is that correct?
Correct.
Okay.
All right.
Okay. The education, I believe, I understand, it looks like I misunderstood that when I made the objection, and that there's no veto power over any extracurricular activities. And I'm not sure about the enrollment, though. Mr. Falcone has concerns that if he finds a school that is suitable for Armando, that Ms. Farrar may object, and it would hinder him enrolling him in that school in a timely manner. Whereas, of course, he would give her notice, and it may be better for her to, if she has any specific objections that can't be worked out, that she seek court intervention at that time.
Right, which is generally how that occurs.
Okay.
But she would need to do so expeditiously, because the last thing I want to do with a child is have them start in one school and then get pulled out and go someplace else. I don't like to disrupt educational situations as much as possible.
Thank you, Your Honor.
So that is going to remain as is, as I understand it, correct?
If my reading of that is correct, then yes, we would agree to that.
Okay.
Okay. The medical arrangements, Mr. Falcone had offered Ms. Farrar, as a gesture of cooperation, that she could, that Armando eye appointments would be in Reno and that she could take him to those. However, Mr. Falcone is concerned if he is excluded from, taking him to an eye doctor in Las Vegas. Matter of fact, Armando needs an eye appointment, and he has been waiting to schedule that until after the phone conference to see how the court orders.
What is the need at this point?
I didn't get into specifics with him. I thought it was more of like it may be his annual, and so he just needs to be tested. I'm not sure if there's a specific need. If he's having difficulties seeing at this moment, that would cause concern before a routine exam.
Mr. Barnes, when is Armando supposed to have visitation with your client next?
I'm not sure, Your Honor. The parties are having some difficulties communicating at the moment. I'm trying to resolve those to see if there's any issues or not. I'm not aware. I don't know yet. I'm waiting on that information. It's been a month and a half or so since she's had visitation, and definitely probably longer than that since Armando's been back to Reno. Based upon those issues and just generally speaking, it doesn't really make sense in my mind to preclude one parent from taking Armando to have medical care that needs to be done, if it needs to be done, just because they're in Reno or if they're in Las Vegas.
If there is a specific need, for example, if Armando has now started to experience an inability to see the board at school, if he's experiencing some kind of eye problem where he needs to see an ophthalmologist or an optometrist or something like that, and it needs to be done soon, either parent has the ability to take the child for that kind of medical service. The routine, if it's a yearly checkup, that happens here. That's what his mother gets to do. More emergent type of treatment, that can be done in either place. Does that help with the problem that we're having?
I believe it will, Your Honor. Ms. Caffaratti
I think that will resolve the problem.
And I can definitely clarify the language to make that clear.
Okay. And that goes for any type of medical treatment. If Armando needs emergency care, he gets it wherever he is. But routine well checks, that kind of thing, that happens wherever the agreement says it's going to happen. And it's up to that parent to make sure that that's done in a timely way so that Armando's current on his shots, that he has his regular dental cleanings, all that kind of thing.
Very good.
Okay. Thank you, Your Honor. I think the last issue is just concerning the transportation costs.
Yes.
It is our understanding that the court ordered that Mr. Falcone be responsible for half of the cost of 4 flights per year only. And so the language in the proposed order states that it cites those 4 that have already taken place and then states that there'll be 2 more in the year 2015. And I believe that the court ordered it was just 4 per year. And Mr. Falcone is willing, Ms. Farrar had scheduled flights in April and May of this year, and she was to provide receipts and he would reimburse her for half the cost. She has not provided any receipts yet. So Mr. Falcone has suggested either he would be willing to reimburse that, of course, or if she would like, he could just get the pay for the half of the Thanksgiving and Christmas, and those would be the other 2 flights, because he has already paid for 2.
Your Honor, I think there's 2 separate issues here. The first is how the rest of 2015 will be addressed.
Mm-hmm.
Ms. Caffaratti says that the 4 flights have already been split, 2 of which can be reimbursed if Ms. Farrar provides the information to Mr. Falcone. If that occurs, then 4 will be split. But the agreement on the record, and I think that might have gotten confused at some point, that, okay, there's going to be 4 per year, but for 2015, they're going to split these 2 holidays. That may be in confusion, I'm not sure, but I'm pretty sure that's what it said on the JAVs. However, if the agreement was 4, and there wasn't a special agreement for 2015, then it would make sense that there wouldn't be reimbursement for the remaining 2 holidays. I'm not sure what occurred. And then the second issue, Your Honor, is how they will be, the flights will be split moving forward. I believe what the agreement was on after watching JAVs is that they will alternate who pays for the flights. That way they're not sending money to each other. And Ms. Caffaratti has stated that they should split each flight. So there's 2 separate issues.
Okay. I'm looking at the minutes here.
So far, everything seems like it's pretty above board. I especially like how this judge said she's looking at the minutes, because that means she's not trying to just re-render a decision from the bench right now, just kind of on a whim. She's actually looking back to see what she ordered at that hearing, which is what she's supposed to do on resolving these proposed order disputes. So nothing really jumping out at me at this point that's of anything that's alarming.
Now, with regard to paying for the flights, What the minutes say is each party may pay for a one-way trip, or the parties may choose how they like to pay in order to equally divide the transportation costs. So it wasn't that they were going to split the flights. Each party would pay for bringing the child to them, for example.
Okay.
If they may find that booking round trip.
This is definitely what you want to do in high conflict child custody cases. You want the parent that is receiving the child to pay the transportation expenses. Even half of those expenses is not good enough, because that opens the doorway for them to say, hey, I'm too poor to send you the child. Sorry, you're not going to get to see your child. And what that ends up doing is causing the other parent, the targeted parent, to be abused. They end up paying additional flight costs to try and get the child to them. It happens all the time in high conflict child custody cases. You want to make it so that the parent receiving the child pays for the trip, because that way you'll be sure that if that high conflict parent says they don't have enough money to get their own child, most likely they're telling the truth, because they typically use the child as a pawn. And so when it comes to them getting the child, they will make sure somehow, some way, that they can afford that flight to get that child to them. But when it comes to getting the child back to the other parent, it's a different situation. Now, some people have said, hey, on the trip back, it's still, there's still conflict. They still pull some stunts and games. It's true, but it's easier to hold them in contempt of court. If you're paying to receive your child, then that all they have to do is get to the airport. It's different. They can't claim, hey, I'm too poor to get the child to you because I had something suddenly happen to me, like my apartment burned down, or I got mugged, or somebody took all the money out of my account, or things are just going bad with finances. These are things that make it a whole lot easier for them to get out of contempt of court. When you have it set up so that the party receiving the child pays the costs, then the other parent now only has to get the child to the airport. And if they can't do that, the door is wide open for them to be held in contempt of court. It's just easier to control the situation that way.
Is more cost effective for them, in which case I would suggest that each book and pay for one holiday, with the understanding that the next holiday the other parent is going to book and pay for that, so that you're still splitting the cost. But it was never contemplated that one party would book and pay for it with the other party doing the reimbursement, because these two don't get along well enough to reimburse.
No, they don't, Your Honor. I think that in fact, they get along so poorly that they would not be able to come to an agreement as to whether on this particular flight we do a round trip or we do one ways. I don't think they'd be able to figure that out between the two.
I agree with Mr. Barnes on that.
Then each party pays for one way, and what they pay for is to bring the child to them.
Okay.
Now, with regard to how we're going to split this, it was contemplated that 4 flights were going to occur. There would be Thanksgiving, Christmas, spring break, and summer or Mother's Day. And in 2015, what has occurred so far, please?
There has been the Mother's Day, which was in May, and then there was also a flight in April, and I don't know if that was for Easter or if that was just a visit. And then I believe that in the beginning of the year, when Mr. Falcone first moved to Las Vegas, there were 2 flights, so January, February. So the only one of those that were surrounded around a holiday was Mother's Day, I believe.
Okay. Well, it says, subject to proof, I'm looking at the minutes again, the parties shall equally divide the cost of the 2 flights the child has previously taken. So as of the time that, as of June, the child had taken 2 previous flights.
Correct.
So they were going to equally divide the cost of those flights. Then going forward, I think, divide the cost of the holidays that we're talking about. So in this particular case, it would be Thanksgiving and Christmas.
And is that for just this year, Your Honor, in addition to the 4?
That would be for just this year. Going forward then, it would be 4 per year. But we had talked about the fact that there were additional visits And so this year, I think the understanding was that this was going to be an anomalous year. But going forward, there were going to be 4 trips a year.
Correct. We would agree to that. Thank you, Your Honor.
So the only language that needs to change is to state that there will be 4 moving forward, and they will be paid with each parent paying for a one-way ticket to bring the child back to them.
Correct,
Okay.
Mr. Barnes. Thank you.
I believe that was...
Let's,
Oh, I'm sorry, Your Honor. Go ahead.
I just wanted to... Looks to me like that's it. The rest of it, I think Mr. Barnes has made changes so that the issue is not ripe any longer.
Correct. I agree that this is all the issues that we had.
Yep.
Excellent. Counsel, thank you very much for approaching this in this way. I find that just talking these things through, we can come to resolution, or I can at least make the call so that we can get the order on file.
I agree, Your Honor. Thank you very much.
Your Honor, I did just think of one other thing, and I know that it was in that you had mentioned that if the parties, Ms. Farrar was to get 1 weekend per month, and if the parties could not agree on which weekend, you would make the decision. Mr. Falcone had indicated to Ms. Farrar that he preferred the third weekend, and he has never heard anything. And so if we could solidify and put in the order which weekend per month, I think that would avoid a lot of problems going forward.
Mr. Barnes?
I agree that it should absolutely be as much that can be spelled out needs to be spelled out. I don't know whether that works best for her or not. Perhaps we can just say the third weekend, and if there's an issue, we can try to resolve it between counsel and then ask for a conference call for just a decision on that one issue. But just set it as the third for now.
Sure. If there's a problem with that, then let me know. I'm happy to take a quick phone call.
Very good.
Thank you, Your Honor.
Counsel, thank you very much. Have a good day.
Thank you. You
Thank
too.
you. You as well, Your Honor.
Bye-bye.
Bye-bye.
Bye.
Here we have the minutes, and I think you guys have gone through minutes enough times to know that I really don't spend a lot of time on them. The reason why is because the minutes do not control the case going forward. The minutes are disregarded the second that the final written order is entered. If you'd like to, you can always go through this yourself and then post something down in the comments below if you have any questions on the minutes that have been entered in this case. But other than that, expect me to go through in detail that final written order with the parenting plan. And the next document we have here is the request for submission, and this is the corrected proposed order that my ex's attorney is submitting to the court for signature. I don't believe any other objections are made. And second page is just the affirmation swearing under penalty of perjury that this document doesn't contain a social security number, or at least affirming it's not under perjury, but it's okay because it's an attorney. I don't know if you guys know this, but attorneys are officers of the court and they don't have to be sworn in. Any statements that they make can be held against them either in disciplinary proceedings or by the court. And next we have the Rule 5 Certificate of Service indicating that this document was mailed to my attorney. And we have the list of exhibits, which contains the proposed order following the June 29, 2015 hearing. We're not going to go through this proposed order because it's unsigned, and I believe that the next video will be the final written order signed by the judge, and that's going to be the video where we go through that. Going into the aftermath, we have, looks like 2 filings, but neither of them were filed by me, so I incurred $0 in costs. My ex's attorney would have filed just a request for submission, but that's a free filing, so she incurred $0 in costs. My attorney was helping me for free, so I incurred $0 in attorney fees. My ex's attorney would have had to been present for the conference, which was about 20 minutes, plus there would have been a little bit of waiting prior and also some prep work to make sure that he had an understanding of the case, so I think it's reasonable to say 45 minutes. Then he would have had to prepare another proposed order, this time with corrections. I think under the circumstances, 45 more minutes is reasonable. That's going to come to an hour and a half at the rate of $250. That's going to come to $375 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.